So let's begin. The IRC includes a total of 325 Houston amendments. And this particular document has all of those amendments showing the differences from the 2012 to the 2015 Houston amendments. But it also includes the significant changes that were pointed out by ICC in their significant changes book that they publish online. That can be purchased from them directly, and you can either get it as a PDF document or as a hard copy. But this particular class is only going to be trying to show you the differences between the Houston amendments from the 2012 to the 2015. All of those Houston amendments are identified in this third column over here by a peach color. If the document is Houston or ICC significant changes, it's identified as a light blue color. So we're not going to be covering those today. We're only going to be covering the Houston amendments. I know that there will be probably some questions associated with some of these sections. So if you'll just take a scratch paper and a section that you have a question about, maybe just make a note on that scratch paper, and at the end of this training session, I'll stay online and we can discuss those questions at that time. But I'm going to probably be rushed just to get through all of the Houston amendments before the 3 hours is over with. So as everyone, I hope, is familiar with, in Chapter 1 of all of the codes, it has more to do with the administrative processes associated with the code and how it's enforced. It's heavily amended by the City of Houston, mainly from our legal department, because they take our business processes and incorporate them into those, into that chapter and into all those sections of that chapter. As you can see, in section R101.1, there were some amendments or changes to that particular section, and those are identified as green highlighted sections, which are City of Houston amendment changes. The green text is new or modified text by the City of Houston in the 2015 code. Now that particular section, R101.1, even though it's been edited somewhat by the legal department, the technical requirements of that particular section has not changed. And you can see that in the third column over here, where we identify the analysis of the changes and how they affect the code. So in this particular case, that first section, even though there were some changes, it doesn't really affect the technical code requirements or the code intent. Now, section 102 or section R101.2, the scope. The previous City of Houston amendment is modified to include minor editorial changes, and there are additional changes that coordinate with changes made in other sections that address height limits of accessory structures. The change to the technical code requirements of this section include the elimination of accessory building area limitations. In the 2015 code, the IRC actually made changes to the definition of accessory buildings and to certain sections of Chapter 3 that eliminate the area limitations associated with accessory buildings for residential structures. So that's what you're seeing in this, in these highlighted code sections here are the changes, the green being the Houston changes and the light blue being the IRC changes. In the previous editions of the IRC, the definition of section R202 placed limitations of 3,000 square feet in area and 2 stories on accessory structures. The 3,000 square foot limitation was introduced in the 2006 IRC based on a concern of the potential fire load in residential accessory buildings. The area limitation has been removed from the 2015 IRC based on the residential setting of these buildings, the need for larger accessory buildings in rural areas, particularly in the city of Houston, which has a lot of rural space, and the fact that dwellings and townhomes constructed under the IRC are limited in area, or unlimited in area. So basically, you can have an unlimited area IRC built structure, residential structure. Now you can have an unlimited area accessory building that goes with that, which will be helpful for these rural areas that might have a barn for storage of their hay or something like that. And actually, the IRC provided a photograph of a barn in their significant changes book to give you an idea of what you might be expecting. There was a new amendment added to R102.1 of the IRC that just basically adds a clarification. It talks about a conflict between a general requirement and a specific requirement, and the specific requirement shall prevail, where in any specific instant the provisions of this code, including adopted appendices, specify different materials, different methods of construction, or other requirements that differ from those provided in the city code or other volumes of the construction code, including adopted appendices in those codes, other than the fire code, and it is adopted appendices and standards, the most restrictive shall prevail. And that's a basic rule in all of the model codes, is if you have a conflicting code, then typically the most restrictive prevails unless the code specifically says otherwise. The Houston Amendment continues by saying, where in any specific instance provisions of this code, including adopted appendices, specify different materials, building methods of construction, or other requirements that differ from those provided in the fire code, including its adopted appendices and standards, the building official and the fire marshal and the building official and the fire marshal are unable to mutually reconcile the requirements by issuing a written interpretation, then either of them may refer the matter to the General Appeals Board created under the building code. That being said, the city of Houston and the Houston building official just released the 2015 code words that are basically interpretations of specific sections of the code that are felt to be needed to help the plan analyst, inspector, and the customers better understand the intent of the codes and how the city of Houston is going to enforce those. A newsletter went out last week with links to those code words so that anyone who would like a copy of them can download them off of the internet, off our Houston permitting website. I would suggest getting copies of those because most of them are very helpful in clarifying specific sections of the code that can be confusing. And we want you to be able to understand what we're going to be expecting to see in the plans based on how we're planning on interpreting that code, usually based on its intent. Sometimes the code provisions aren't very clear. In section R102.5 appendices, you'll notice that there were several new appendices adopted in this particular code section, or in this particular code adoption. The existing amendment was modified to include appendices K, which is the previous sound transmission for IRC townhomes only. Appendix M is an appendix for home daycare, which was requested to be adopted by the fire department to help clarify specific requirements for home daycares. Appendix Q is the airport sound attenuation requirements. We also adopted a new appendix that we pulled from the 2018 code back to the 2015 code, It is Appendix T in the 2015 Houston Amendments for tiny houses. So now that tiny house appendix is adopted, you will be able to construct tiny houses to that specific appendix in the city of Houston. In addition, Appendix U is adopted for the solar ready, and that appendix is adopted to correlate with the IECC, which already includes a solar ready appendix as part of its Houston amendments. For existing buildings in section R102.7, existing structures, the legal occupancy of any structure may continue on the date of its adoption of this code shall be permitted to continue without change except as deemed necessary by the building official for general safety and welfare of the occupants and the public. Basically, the previous Houston Amendment was brought forward into the 2015 code, and no change to the technical code requirements for this section actually applies. I mean, it's just the same as it was previously. R102.8 special piping and storage system. In the 2015 code, it just said see the fire code. We got a little bit more specific in the 2015 code and actually identify the chapter that you need to be looking at for special piping systems. There's really no change to the code requirements other than us trying to be a little bit more clear with the amendment. Same thing with the electrical code in section R102.9. You can see that the Houston Amendment was brought forward from the previous Houston Amendment. We modified it to clarify that we're talking about the 2015 International Residential Code. But the technical requirements remain the same for that section. For the next section, which is R102.10 Mechanical Code and R102.11 of the Plumbing Code, the previous Houston amendments were brought forward. There's no change to the technical requirements or the code intent. The same is applies to R103, which creates building code enforcement as the enforcement agency for the city of Houston. You'll notice that there are some highlighted sections, but it doesn't change the technical requirements of the code. It's more to do with the fact that the Public Works Department is now just called Houston Public Works instead of the Houston Public Works Department. The previous City Houston Amendment in section R104.8 for liability was modified and includes minor editorial changes, but there's no technical change to the code requirements or code intent for that section. There was a Houston amendment that legal department deleted R104.81 legal defense. It wasn't in the previous code, but the legal department apparently felt like it wasn't necessary, so they eliminated that code section completely. Modifications. In R104.10 for modifications, a City Houston amendment was added by legal to include the name of the building code enforcement branch of Houston Public Works for clarity. There's no change to the technical code requirements or code intent for this section. I'm going to skip over the significant change section that was added to this document. In R104.12, we just brought the previous amendment forward. There was no changes to that particular section. Now in section R105.2 is work exempt from permits. There's some changes to this section that you probably want to be aware of. The existing amendment was modified to coincide with the provisions of the building code for accessory structures and now includes the following additional changes. A change now requires a permit for electrical fences for a field inspection for compliance with the requirements specified in the city code. There was some complaints made to city council and to administration and building code enforcement that the city code requirements for electric fences and barbed wire and razor wire fences were not being enforced. So They asked us to make changes to require a permit so that an inspection can be made. I don't have anyone. Okay. Sorry about that. Let's see, where was that? Here we go. The second big change was the City of Houston change and now identifies specific minor repairs that are exempt from obtaining a building permit. That's item 6. These particular items were already identified in pamphlets and handouts that recognize that these particular items did not require a building permit, but because the code did not include them as exceptions to permits, we were asked to please include those in the exemptions section. So they've been added so that it's very clear that now that if you look up the exemptions from permits, you'll see these particular items. It shouldn't be a change in how the city has been issuing or dealing with these types of construction, small construction repairs. But at least now it's in the code so that if you want to refer to it, you can see it. A change eliminates the permit exemptions, prefab swimming pools less than 24 inches in depth due to the requirements of the health department and the state minimum and city adopted 2018 ISPSC. That's the International Swimming Pool and Spa Code. The state just updated the swimming pool and spa code to the 2018 edition of that code published by ICC. And the City of Houston has adopted that code with the adoption of the 2015 codes. So now you'll have that code also that you'll have access to from the City of Houston and from the ICC for building swimming pools. Oh, you got it. Continuing on, R105.21 emergency replacements or repairs. This is another item that was recognized by the City of Houston, where we typically allow emergency repairs to be done and a permit be pulled within 24 hours, but that was never actually specified in the code. So we wanted to actually put that in the code so that you have access to those code requirements. So basically what it says is where emergency equipment replacement or emergency repairs for which a permit is required must be performed, the permit application shall be submitted to the building official not later than the next business day after initiation of the replacement or repair. This will eliminate field inspectors from double feeing someone who started work when they're just trying to close up a building because a car crashed into it or something. I mean, we want you to protect your property, so we wanted to have this put in the code so that you'd have something you could point to. It doesn't change how the city does business. We've always allowed that to be done that way. We just never had it in the writing, so now it's in the code. And there's an amendment to section 105.2.2 for repairs, which basically points back to that same thing for emergency replacement or repairs. There's no change to the code intent or to the code requirements for that particular type of work. A City of Houston amendment was added to section R105.3 application for permit to clarify that the square footage associated with all new construction and remodel alterations must be included with every permit application. And you can see that here. That was the amendment that was added. It just basically indicates that you have to provide that information when you're filling out your permit application. And part of the reasoning is the fact that the City of Houston now bases the permit fee on square footage instead of valuation. Hopefully the valuation boxes will be grayed out at some point in the future so that you don't have to put anything in there. And then, to be honest, it shouldn't force you to put evaluation in there now, but it might still be doing that. They're in the process of updating the iPermits portal, so the applications don't require the evaluation to be put in there, but just allows you to put it in if you want to. The thing that we're actually interested in is the square footage of the scope of work that you're doing. The next section was brought forward from the previous section for R105.3.1.1, which talks about the determination of substantially improved or substantially damaged existing buildings in flood hazard areas. The city flood department has a city code of ordinances that addresses construction in flood hazard areas. And although you do have to comply with the code for any new construction in those areas, the flood department is the one that determines when something's typically substantially damaged. And they also require you to submit the cost of construction for those, for any scope of work going on in the floodplain, because they keep track of how much improvements you're doing to a building in a flood hazard area. For this very reason, they use that valuation to determine if and when you have to upgrade to new construction. Section R105.3.2 is time limitation of application. There's always been a section in the IRC that has a time limitation for an application. City of Houston has amended that to include a time limit on permanent applications that become effective and eventually expires. This time limit is based on state law and historical city practice. State law allows 2 years from the time an application is submitted to it being issued a permit. Now, after 180 days, the application may become inactive and have to be reactivated, but it's not expired until it's been abandoned or exceeds the 2-year time limit with no progress on the application. Validity of permit, there's a Houston amendment in this section, R105.4. It was added to eliminate duplication and the possibility of a conflict. It doesn't change how the code has been enforced from previous code cycles, and it shouldn't affect anyone when they're submitting their plans. Expiration, R105.5. As in previous code, there was a Houston amendment in this section. We brought that same amendment forward. It's been edited slightly to coincide with state law and historical city practice. Even though some minor edits in this section, as can be seen where the green highlights are, it doesn't change the intent of the code for that section. Extensions. A City of Houston amendment was added to specifically address the building official's authority to provide permit extensions. It was strange because the building code does address extensions. So when it's not addressed in one code and it is addressed in another, we rely on the code that it does include it in order to enforce the intent of the code. But now the IRC does include this section in it. It didn't previously. Suspension or revocation. The previous City of Houston amendment for R105.6 was just brought forward. There's no change to the technical code requirements or code intent for this particular section. The same is true for the deletion of R106.1.4, information for construction in flood hazard areas. As previously indicated, we have a city code that addresses flood hazard areas, and we rely heavily on that particular ordinance. Schedule of permit fees. This section was edited slightly to indicate the specific section in the building code that has the permit fees for residential construction. as with most fees, they're identified in the building code or the city fee schedule. And if you go to section 118, even though you'll see specific fees for certain items, most of the fees, and including those, are all identified in the city fee schedule. R108.3 was amended to identify how the fees are being calculated for single-family residential construction and townhomes. The structural building permit fee for new 1 and 2 family residential buildings and townhomes and their detached accessory structures will be calculated as specified in 118.2.1 and tables 118.1 and 118.2 of the building code. And those are the new fee schedules that identify the square footage. This amendment changes the method of calculating a building permit fee for new single-family residential structures, additions, and alterations. Fees are based on the aggregate square footage of new construction plus the total square footage of all footage or alterations. New construction will be comparable to current method of calculating based on valuations. Alterations will be based on 20% of what a permit would be for new construction, having the same square footage of the altered or repaired construction. So the city of Houston is promoting the repair and maintenance of their buildings by actually giving a break on the permits for those remodeled areas. Instead of it being based on the total value of that remodel, it's just based on 20% of new construction, which is typically what it takes to do a remodel for a particular area, is 20% of new construction. Refunds. As you can see, the previous Houston amendment was brought forward. That's identified by this gray highlighted area. There were some minor editorial changes applicable to refunds that correlate to other volumes of the Houston Construction Code that had to be identified in this section, but there's no change in technical code requirements, the code intent, or how the city applies for issuing refunds on permits if they qualify. Work commencing before a permit. As you can see, the previous City Houston amendment was just brought forward. There was really no changes at all to that particular code section in section 108.6. Plan review fees. The previous City Houston amendment was also brought forward. There were some changes, but the technical requirements and the intent of the code did not change. City Houston Legal Department reworded the particular section to try to be more clear with how the plan review fees apply to a particular project. Deferred submittal plan review fees. The previous City Houston amendment was reorganized and relocated to this section from the previous section, which was 118.2.8. Now it's in 108.7.6. And this is where this particular document helps. It shows you where a section or a code requirement was provided in a previous code, and be done in about an hour and a half. So you can see this particular code requirement was in the building code previously, and now it's been added to the IRC. But there's no technical changes. Previous City Houston amendment for 118.16, which was a building code excerpt annual fee increase, was omitted from this code and retained in the building code. There's no change to the code requirements. Fees will continue to increase annually based on the inflation rate. There was a previous City Houston amendment for floodplain inspections that was located in 109.1.3. That section just referred to Chapter 19 of the City Code, and even though that code still applies, it wasn't felt that it was necessary to show it in this particular code section, because there's several other code sections in the IRC that refer people to Chapter 19 of the City Code for floodplain construction. Now, Section R110 is titled Certificate of Occupancy. There is a Houston amendment to this section that changes Certificate of Occupancy to Certificate of Compliance. And although in previous code editions, a Certificate of Occupancy and a Certificate of Compliance wasn't a requirement, now it is. The previous City of Houston amendment was modified to now require a certificate of compliance prior to occupying any new addition or new 1 or 2 family dwelling or townhouse. Now, that doesn't mean that if you have an existing single family residence that you have to get a certificate of compliance to occupy that building. We're talking about only new additions and new 1 and 2 family dwellings and townhouses. From this point forward, we'll have to have a before they actually can occupy the building. One of the reasons is we want to make sure that all the inspections have been completed, signed off, and finalized prior to someone moving in. We have a long history of residential construction not being completed and people moving in and utilizing the temporary utilities to move in their building and then not ever notifying the City of Houston that they're ready for their final inspections. We have a lot of, we have literally tens of thousands of projects that never get finalized and closed out because of that. So we're hoping that by requiring the certificate of compliance for all these buildings, just like we do for our CO for all commercial buildings, that this will help ensure that these buildings get their final inspections and get closed out. For section R110.2, change in use, the previous City of Houston amendment was modified to provide the correct code references, but there's no change to the technical code requirements or code intent for this section. So the previous code identified Chapter 3412 or Chapter 34 and Section 3412.2.1 of the Building Code and Appendix M for a change in use. That chapter and that appendix is no longer in the Building Code. It's now in the existing Building Code. So if you're doing a change of use, then this new section, or this section now, refers you to the appropriate sections in the existing Building Code where you have to go to do that change in use. And that typically talking about going from an R3 to some type of commercial business. In section R110.3, certificate issued, the model code is retained and the City of Houston amendment was added to identify specific information that must be shown on the new required CC or certificate of compliance. The changes that were added is that the building official is going to have to make sure that they show the project number, because this was what the information that has to go on the certificate of compliance. So it's really nothing that the applicant has to worry about. It's information that the building official and the plan analyst is going to have to make sure is identified on the CC. It also is going to require the use and occupancy of the building, the type of construction as defined by Chapter 6 of the Building Code. Temporary occupancy. In the previous code version of the 2012 code, this entire section was eliminated. The City of Houston amendment was updated to just add the certificate of compliance requirement, and now this section is retained as model code, except for those 2 small changes. In R110 revocation, the building official is authorized to suspend or revoke a certificate of compliance issued under the provisions of this code in writing if there's an issue with a particular building. That typically won't happen unless it is a real danger to the occupants. And prior to taking such action, the building official has to provide notice of a right to a hearing on the matter pursuant to the building code section 117. So the City of Houston amendment was added, and it basically reflects the same process that we do for commercial buildings now, but now it applies to residential structures that will have a certificate of compliance. In section R110.6, certificate of compliance availability, the City of Houston amendment was added to clarify that the required CC must be available for review at the residence. This is a standard City of Houston practice for all buildings currently or previously in commercial buildings, but it will have to be available somewhere at the residence in case an inspector wants to look at it. This particular section, R112.1, general requirements for mechanical and plumbing issues. The previous City of Houston amendment was just brought forward. There's no change to the code requirements or the code intent. Same thing applies in the very next section, R112.2 for mechanical. Previous City of Houston amendments just brought forward. No change to the technical requirements. There was a previous City of Houston amendment that talked about substantial improvement in flood hazard areas. That's no longer in this section, or the 2015 IRC no longer has this particular section. It was relocated to R105, which we've already discussed, but basically there's no change to the code requirements. Criteria for issuance of a variance for flood hazard areas. Again, it's the same thing. The Houston amendment was relocated to R104.10.1. We talked about that earlier, but the code requirements have not changed. There is a variance process, but you have to go through the flood department. R112.3, plumbing. There were no changes made to the previous City of Houston amendment. It was just brought forward, and you can see that by virtue of there's really no color changes in here. The previous text that was struck is struck again in the 2015 code. Penalties. There's a section R113.4.1 that addresses penalties for violations of the code. Nothing's really changed. There was some minor editorial changes, which are highlighted in green here, but the code requirements did not change. Neither did the penalties, so they remain the same. Private plan review and inspection services. Anyone that's on this training class probably already know that there is a section of the code, this 115, for private plan review and inspection services. The previous City of Houston amendment was modified to combine the code provisions of the 2012 IRC code sections R115.1 and R115.2, but there's no changes to the code requirements. So basically, we took the previous two code sections and just combined them into one and tried to simplify it. In section R15.2, program established. This is our third-party program where the building official has the authority to establish a private plan review and inspection program. These requirements remain the same. There was this one minor change based on the Houston Public Works changing the name of its department, but as you can see, there were no other changes to that code requirement, so they remain the same. The requirements for that program for oversight also remain the same. No changes. We just brought the same previous Houston amendments forward and the same is true with R15.5, which is the fees. So all of those remain the same. There's no changes. There have been some modifications to certain definitions in the 2015 residential code. The existing amendment for R202 and R201.3 was modified for clarity. The section clearly identifies that where there is specific rules of construction or terms not included in this code, the IRC, but addressed in other volumes of the Houston Construction Code, those rules continue to be applicable as if they were provided in the IRC. This particular code requirement has been in the code in every edition that I've ever seen. So there's no real change to the code, but it is a seldom known section that people, don't normally read. And it is understood that if there's something that is addressed, like in the IBC, for instance, I give you an example, driveways and sidewalks. There's nothing in the IRC that talks about driveways and sidewalks, but you still have to comply with those codes because they are city ordinances. They're part of the Houston Construction Code, and any new development requires compliance with those construction scopes of work if the right trigger is hit. The City of Houston amendments added to correlate with specific terms provided in the city code and to clarify certain terms used in the codes or to clarify the code intent for those terms defined, such as alley. I know that there's a huge discrepancy with alleys in the city of Houston. There's all kinds of alleys. The code has its own definition. OCE has several definitions of alleys, and I know that there's several departments that are working together with legal to try to figure out a basic definition for alleys that can be used for all the different departments, but that hasn't been established yet. They're working on that. So you may want to stay in touch with our Houston Public Works email notices to see if there are any public meetings that you want to attend when they start trying to establish the definition for alleys. But there is an alley definition in the IRC, and any definition in one code applies to the other codes based on this previous code section that we talked about. The IRC now includes authority having jurisdiction. It was not included, that definition was not included in the IRC, but it was part of other codes in their definitions, like the building code, I think, had a definition of authority having jurisdiction, and I believe the fire code did too in the previous code versions. The definition for building code was had just a minor edit, but it basically was adopted and brought forward from the previous code section. Building official was expanded and includes a little bit more information now, which is mainly related to how the building official and his deputies are formed internally. It also now talks about or includes the Houston Airport System building official. So the definition now actually includes the Houston Airport System building official. And I don't know, most of you guys might not realize, but there is a building official specifically for the airports. And this particular definition now establishes that. Certificate of compliance definition was added to the IRC because there wasn't a definition in there that identified what that was. The city fee schedule definition was added to the IRC, and a new definition for code official was added to the IRC. Matter of fact, I think code official was added to the IBC also. The amendments were added to correlate with specific terms provided in the city code and to clarify specific terms used in the codes or to clarify the code intent for those terms defined. The code talks about code officials in a lot of different places, and yet they didn't ever provide a definition for code officials. So that has now been addressed. The construction code is addressed in the city code of ordinances, and now we have a definition in the IRC that basically references to that section of the city code. So if you wanted to see what the term construction code means, you could look at section 1-2 of the city code, and it defines what the City of Houston construction code is. Control joint was added at the request of stakeholders and field inspectors to help identify what a control joint is for certain types of construction, because apparently in some situations there was some confusion about that. So a control joint is a one-piece joint made of metal, zinc, or plastic installed in the surface membrane only of plaster or stucco finish in order to allow for stress relief and to reduce minor cracking of the surface. Control joint may not serve as an expansion joint. Hopefully that definition will help the field inspectors and the contractors when they're doing stucco. There's also a definition added for dangerous because there is a definition in the city code. So city legal wanted to make sure that the building codes, each of the editions of the building codes matched what the city code defined as dangerous. So now there's a definition for that that identifies what chapter and article of the city code if you want to see what the definition is, but it's basically exactly what it says in here. Duplex is an individual freestanding structure containing not more than 2 dwelling units, single-family dwellings, or household, each containing a separate means of egress. So now there's a definition for duplex, trying to just be more clear, make sure that everyone understands what the intent of the code is when they're talking about a duplex. The electrical code definition was updated to match what the current City of Houston electrical code is. Energy conservation code was defined to be a City of Houston residential energy conservation code, because that's all we're really talking about for this particular book. We also identify or add a definition for existing building code because now that is part of the Houston construction code, since chapter 34 was deleted out of the building code, and now it only refers over to the existing building code for additions, alterations, repairs, remodels, and change of occupancy. Fire code official definition was added at the request of the fire marshal. The same definition is in the fire code. There was a previous definition in the 2012 code for gray water that was brought forward. A minor edit, but it didn't change anything as to how that is applied. Let's see. As you can see, the previous Houston amendments that addressed each of the codes, International Building Code, International Energy Conservation, those were all brought forward and updated to the current codes. But it basically is saying any reference herein to the International Building Code or any of the other ICC published codes is a reference to the City of Houston code that correlates with that particular topic. There was a new definition added for the International Swimming Pool and Spa Code since the state adopted and updated its swimming pool and spa code, and the City of Houston has adopted that code that had to be updated. A definition for means of egress system was added to the IRC. And then the IRC also added a definition for the 2012 code for gray water that was brought forward. A minor edit, but it didn't change anything as to how that is applied. And I mean, even though it wasn't necessary because there is a definition in the building code for means of egress, where we were just trying to make the IRC as complete a code as possible so that you wouldn't have to have another book in order to find out what a particular definition or term is defined as. So adding a means of egress hopefully will help contractors know what that means. Multifamily residential structure is a new definition added to the IRC, and it's defined as a structure including a townhouse structure that is constructed with 3 or more attached single-family residences, dwelling units, apartments, or condominiums. This definition is only related to how the IRC is used and applied. Has nothing to do with the city code. If there's a city ordinance that has a definition that's inside that particular city ordinance, and it defines multifamily residential structure in a different way, this particular definition has nothing to do with that ordinance. The ordinance definition would apply in that respect. This particular definition only applies to residential structures constructed under the IRC. City Houston Amendment added to correlate with specific terms for 1 and 2 family dwelling. I'm sure when you look throughout the IRC, you'll see that term used continuously, but yet there's no definition for 1 and 2 family dwelling. I've heard people debate at the national level about putting a definition into the IRC for this, and the argument seems to be that that's basic code, knowledge. No one should have to be told what a 1 or 2 family dwelling is. But unfortunately, if it's not defined, then it causes problems. So in this case, 1 and 2 family dwelling is an individual freestanding structure containing not more than 2 dwelling units, also referred to as a dwelling duplex or a single family dwelling, depending on the number of dwelling units within. So a 1 or 2 family dwelling is both a duplex or a single family residence. But it is not a townhouse, because a townhouse has 3 or more dwelling units. Patio cover is now defined a structure with open or glazed walls that is used for recreational outdoor living purposes associated with a dwelling unit. Let's see. There was no amendment in the previous code for patio cover, even though that's a common term that's used throughout the IRC and the IBC for that matter. The previous plumbing code definition was brought forward, so that remains in the code. And as you can see, there's a lot of blue highlight. Those are new codes, or new definitions added by the model code. There's a definition now for red code. City Houston Residential Code has adopted and amended by this jurisdiction. Right of way, the entire area between the property boundary lines of every way, including but not limited to roads, streets, alleys, highways, boulevards. That was added to help define what the right of way is. Sign code is defined. Single family dwelling, an individual freestanding residential structure intended to serve a single family or household as a dwelling and or other uses authorized by the building code or residential code. Substantial damage, a condition where one or both of the following apply. This code section comes straight out of the city code, and the city legal department added it to clearly identify what that means. We also added a definition for swimming pool and spa code. Thought I already said that. Townhouse definition was modified. An amendment added, basically defines a townhouse as a multifamily residential structure constructed in a group of 3 or more attached single family dwelling units. in which each unit extends from the foundation to the roof and with a yard or public way on not less than 2 sides, which may or may not include lot lines or property lines separating each dwelling unit. Unsafe buildings is now defined. Building structures or equipment that are unsanitary or that are deficient due to inadequate means of egress facilities, inadequate light and ventilation, or that constitute a fire hazard, and or in which the structure or individual structural members meet the definition of dangerous. This definition was added to help certain departments identify when a building is truly dangerous. Wind limitations. R301.2.1.1 has been updated to identify the ultimate design wind speed as calculated in accordance with table R3 and meets or exceeds 140 miles per hour. This particular building code would not apply if you exceed 140 miles per hour. Or let me rephrase that. The prescriptive provisions of this building code would not apply. You have to use, as you can see in this section, one of these 6 picks if the wind speed exceeds 140 miles per hour. It's very likely that we won't run into too many buildings where the wind speed exceeds 140 miles per hour in the city of Houston. Typically, you might run into that down in Clear Lake someplace close to the lake or close to a water source. But as a general rule, it looks like most locations inside the city of Houston are going to be required to meet 139 mile per hour wind speed. And that the wind speed requirement is established based on a table in the IRC, which we will come to in just a short time. And then you basically will be putting your specific address in a website, and that website will identify the wind speed for that particular address. You're supposed to print out that document and attach it to your plans or upload it with your plans when you're submitting. Wind speed, there's a, let me get down to the next Houston Amendment. Floodplain construction. Section R301.2.4, buildings located in flood hazard areas must comply with the provisions for the most restricted flood hazard area and may use ASCE 24 for design. So those requirements are part of the base code and are not struck like they may have been in previous code sections, but in this particular section, it didn't delete it. Okay. Table R301.2 parentheses 1, climate and geographical design category or criteria. This is the table that I was talking about where you locate the wind speed website, where you would actually go to this website here, put in your address for that particular site, and then it will identify what the wind speed is for that particular area, and you will design your building for that particular site to meet those minimum requirements, those minimum wind speed requirements. There's no longer a single wind speed applicable to the entire city. Each site has its own specific wind speed. But as I said, we test a whole lot of different locations, and we kept coming up with 139 mile per hour for all the different sites inside the city limits of Houston. So it's probably going to be about 139 mile per hour for all of them. Exterior walls, there's a Houston amendment that was in the previous code section that was brought forward, but it was amended, and the existing amendment was modified to for clarity to document the model code intent. Unprotected roof overhangs are now permitted to project to within 2 feet of the property line when fire blocking is installed between the top of the wall and the roof sheathing. As a basic rule, projections are not permitted less than 2 feet from the property line. For dwellings with or without fire sprinkler protection, penetrations of exterior walls do not require fire resistant protection unless they're located less than 3 feet from the property line. There shouldn't really be a change to the base code requirements for this particular section, but there is a change to the exterior wall fire protection requirements based on table R302.1 The previous code section that was Houston amendments that allowed the residential exterior wall to go down to 3 feet and be unprotected. And that amendment is no longer in the Houston code. So basically, the table has gone back to the minimum nationally recognized standard of 5 feet. If your exterior wall goes within the distance of 5 feet to the property line, now the wall has to be 1 hour rated construction as required by this table. There was a footnote C, opening requirements do not apply to non-combustible carports open on 2 sides. So the carports get a break on the 25% area limitation by not considering that by not considering the opening protection requirements of 25% limited for that area. In the past, there was always some issues with carports running alongside property lines 2 feet from the property line and having more than 25% of the area of that carport open to the property line. So this appendix or this footnote C addresses that by basically saying the opening requirements do not apply to that carport on that side. Dwellings with fire sprinklers. Even though this table has been in the code for a while, you know, most residential buildings in the city of Houston aren't sprinklered with a 13D sprinkler system. So we don't see many people using this this table. But because the previous table now goes back to model code, it's very possible that we will see more residences or more designers utilizing this second table that allows sprinklers to substitute for the fire rated construction for those exterior walls that are within 5 feet of the property line. We did add a footnote to address and coordinate and compliance issue that is not specifically addressed for single family residential carports like before. The carport is exempted from the opening limitations specified for exterior walls. Let's see. Dwelling garage fire separation. The city's amendment was omitted in section R3026 and relocated to A of table R3026. So in the table, the footnote now includes that entire previous Houston amendment that was in the separation requirements under R3026. So the disappearing or roll down attic stairs can still be used and may be installed in the garage ceiling provided the garage side exposed panel is not less than 3/8 inch thick, fire retardant plywood, untreated plywood protected with 1/2 inch thick gypsum board, or untreated plywood coated with 60-minute rated intumescent paint. In all cases, the opening protection material must be applied to the garage side of the plywood. And this is to prevent fire from penetrating the ceiling membrane and then traveling through the attic into other areas of the house. Let's see, when did we start this? At 10? Okay, I got about 30 more minutes before we're going to take a short break. No model code changes were made to R303.4. There were some minor editorial changes to the previous City Houston amendment, but The changes do not affect the technical code requirements or code intent for this section. Let me scroll down to the next Houston Amendment. In section R31015, yards and courts, the previous IRC amendment was deleted and relocated to IRC 2015 section R31111. So I'm going to scroll down right here. So you can see where it was located in section 310 of the 12 code, and now it's located in 31111. But the Houston Amendment was just slightly changed to clarify the code intent and to assist the code users. Additional code provisions, minimum dimensions, other yard and court requirements are provided in the model code of the IBC. It helps, this new addition identifies that yards and courts shall not be less than 3 feet in width and shall be open to a continuous and unobstructed path of egress travel to the public way. And that's just to make sure that if that the fire marshals can access the emergency escape and rescue windows, and that the people, if they happen to have to be rescued out of those windows, can actually get through to the front yard. Automatic sprinkler systems. The previous IRC amendment in section R313.2 is retained due to specific restrictions of the Texas Occupation Codes 1301.551I, prohibiting a municipality from requiring fire sprinkler protection to be installed in any new or existing 1 or 2 family dwelling. So you can see that the amendment was retained. We struck the requirement for sprinklers, which is a model code requirement. But as in the previous code, townhouses that meet the definition of townhouse in the IRC or the IBC are required to be sprinklered with NFPA 13D or in accordance with section P2904. Let me scroll down. Protection against subterranean termites. In the previous code edition, section R18.1 was completely struck out of the code. And because we had a mandate to eliminate as many Houston amendments as possible that couldn't be justified, we had to eliminate that previous Houston amendment because it couldn't be justified in the city of Houston, particularly when we're in a heavy termite area as identified by the code and other publications. This area has a huge problem with subterranean termites, and we had no way to justify eliminating this particular code requirement for the Houston area. Address identification. The city of Houston kept the previous Houston amendments and references to the city code, but it was also modified to provide additional details based on certain city code requirements. Although there's no actual change to the code requirements or code intent, this amendment looks like it's changed a lot, but it's just to help clarify certain things. See, so R322.1 general requirements now includes a Houston amendment where a conflict exists between the city code and this section of the city code prevail. And where a variance has been issued by the floodplain management office, the provisions of the variance shall prevail over both the applicable terms of the city code and this section. So basically, city legal department helped to clarify this particular code section to indicate what prevails when certain code sections apply to a particular scope of work. There's an addition, a new City of Houston amendment was added to coordinate with the Texas adoption of the 2018 International Swimming Pool and Spa Code as the state minimum pool code, which is also now adopted by the city. So we added a new section to the IRC to basically point to the appropriate chapters of the state and the swimming pool code, which is now adopted by the City of Houston. Foundation elevation. In this section, R401.5, we brought the previous Houston amendment forward. The city legal department wanted to make some minor edits to it to make it more clear. So that's what they did. The changes do not affect how the code is applied or the code intent. So it's basically the same as it was previously. Structures have to be elevated not less than 12 inches above the nearest sanitary sewer manhole rim of the sewer connected to and serving the building. Or when no sewer is available, the top of the finished floor of the first story of the building or structure shall be elevated not less than 4 inches above the crown of the street. Plans and applications. The previous code amendment, the Houston amendment, was brought forward for the next 3 code sections. There's no change to the code requirements or the code intent. Let me go down. As I said, I'm going to be offering this document to anyone who would like a copy of it to help them if they think it will. In section R404.1.3, the City of Houston had a previous amendment that we brought forward. It just strikes the last sentence of the paragraph. Doesn't change any of the code requirements or the code intent. Let's see. Now, in R501, fire protection of floors, this previous City of Houston amendment was relocated to the model code section R302.13, which we've already passed. So we talked about that already, but it basically just relocates it to a new section. There was a modification to tables R502.3.1 and parentheses 1 and 2 for there were multiple revisions, have to do with floor joists, spans for common lumber species, changes to the southern pine, Douglas fir, larch, and hemlock fir lumber capacities have changed. The floor joist span lengths in the prescriptive tables of the IRC. Spans for southern pine decreased. Lengths for DFL and HF joists have increased. Previous City Houston code word was updated the previous code to include those changes, but now these changes are in the IRC tables and so that code word is now no longer in the 2015 codes because all of these tables have been updated with the newer spans. You can see this is an example of one of them, how it changed. All of these underlying links have changed for all these different species. So the IRC's catching up. Let's see, go down to the next Houston amendment. As you can see, there was a lot of significant changes to the IRC by the model code. The previous City Houston amendments that was in R611-1 for exterior concrete walls was brought forward. Same thing for R613.1 for structural insulated panels, SIPs. Those 2 amendments were brought forward and there were no changes to those code requirements other than just bringing them forward and being located in new sections. As you can see, the model code relocated those particular sections to a different section. In R703.7 for exterior plaster, there's a new exception. It basically says lath may be continuous behind control joints. As you know, we talked about control joints earlier. There's a definition for control joints, and this was one of the issues that contractors were having in the field associated with control joints for EFIS and stucco and some of the other applications, where the field inspectors didn't want the control joints to have the lath running behind those control joints, because they were looking at them or interpreting them to be part of expansion joints. And that's not what they are. That's why we added the definition, and now that's why there's an exception here for control joints. So this should help maintain the current practice in the field, and now be something that the field inspectors and the contractors can point to as a reference for it being in the code. Previous City of Houston amendment in R807 for attic access was eliminated out of R807.1 of the model code. Editorial changes were added by the model code to clarify the code intent. And as you can see, the model code actually struck that entire sentence out of it. So it's no longer in the model code. Fire classification, R902.1, roofing covering materials. There was a previous Houston amendment that talked about, it was an exception for residential outbuildings, and I guess that's accessory buildings. Residential accessory buildings, they were exempted from the roof covering materials, apparently. Well, the City of Houston amendment was omitted because specific provisions apply to the residential accessory buildings in the model code provisions, and the amendment is not justified or needed. You can find specific sections in the IRC that actually eliminate a lot of different requirements for the accessory buildings. They don't even have to meet the exterior wall requirements, I believe. So it was felt it wasn't needed in the as a Houston amendment. So in section 905.7, there was a previous section in the 2012 code that addressed wood shingles, and there was a specific amendment in the IBC that addressed those same items, and that has now been added to the IRC section. So the City of Houston amendment was added to correlate with the existing IBC amendment to provide a minimum level of fire safety intended to prevent the spread of fire from falling cinders associated with adjacent fires. I don't know if anybody realized it, but there was a big fire, I think back in the mid 80s, where cinders from wooden shingles fell across other buildings that had wooden shingles, and the fire spread throughout the entire neighborhood and burnt down a whole bunch of buildings. So for a long time, wooden shingles was completely prohibited in all the codes. But then with the advent of fire retardant treated materials, that changed. And so that's basically what is in this new code section. It basically says the wood shakes have to be fire retardant treated. And you're allowed to use wooden shingles if you meet those fire retardant treatment requirements. In section R10 06.3 exterior air intake. There was some text that struck out, nor shall the air intake be located at an elevation higher than the firebox. And what we're talking about is for chimneys and fireplaces. Well, the previous City of Houston amendment was omitted. The model code addresses all these requirements sufficiently, so there was no need for us to actually strike that out. In the IRC Chapter 11 energy efficiency, we brought the previous City of Houston amendment forward. No changes, so you still have to comply with the 2015 volumes of the Houston Construction Code for energy compliance. That doesn't change. Yes. So we're gonna take a 10-minute break. Okay, so do I need to let them in? I was just notified we're getting close to the break time. I mean, we can go ahead and break a little early if y'all want to. Take 10 minutes, and I'll see you back here at 11:35, and I'll start up again.